Can you dig it? Can you dig it? Can you dig it?
Hey, yeah, boy.
What's the deal, man?
You're on my property, you pulled up to my house, and you start asking me questions. I don't want to talk to you. I don't have to talk to you. Get off of my property.
I'm here because people were looking at
I don't give a fuck why you are here. Get off of my property. Get in the house. Get in the house. I don't need you to explain nothing to me. I know the law.
Okay.
Get off of my property.
I'm telling you, I have reasonable suspicion.
I don't care what your suspicion is. There has been no crime committed on my behalf, on my property. Get off of my
Going
property.
in circles about this.
Dude, this is called harassment. I cannot wait to go up to the court. I cannot wait to go up to the court. I don't have to
I
wait.
have to wait for someone to talk to the guy that called in.
Get off of my property. Get off of my property.
Not you. We leave.
Get off my property.
That's why we're hanging out and talking.
Get off my property.
Man, that's not how this is gonna work.
This is how it works. You can't come up to someone else's private property and harass them.
Someone's breaking into the cars down the road.
I don't give a shit. That has nothing to do with me. Go do your job.
That's what I'm trying to do.
Then get off my property.
People who are breaking into cars.
Get off my property. You are harassing me.
No, unfortunately.
I've asked you to get off my property. I don't want to talk to you. I don't have to talk to you. Get off of my property.
No, I don't want to do this in front of your kids.
Yo,
man.
you're exactly. I'm on the hammock. He pulls up and he starts talking like I have reasonable suspicion to pull up to your
That's
house.
not how that happened. And you know
It's on camera.
All I did was ask.
Was your camera on?
Did you see?
Is your camera on?
Yes, it
And
is.
what did I say to you? I don't want to talk to you. That's what I said. Get off my property.
Oh, he was right here. All I did is ask, hey, do you see anything? And he walked away inside. Okay. I'm like, okay.
I don't have to talk to you.
Well, wait for a better description. And now we're in a pissing match. Okay. So that's
Do
all.
you have PC for him?
I don't have PC for him. All I
Right.
said is
You want
suspicion.
to? Do you want us to explain what's going on?
I don't care. That's why as soon as he pulled up to my house, I'm on my hammock. He pulls up to my house, starts asking me questions. I said, I don't want to talk. I walk in the house. Now he's harassing me.
Okay. I'm the supervisor. Did you want to talk to me?
Yeah.
No, I want him to get off my property.
Now he
Shane, just
doesn't-
go ahead and leave the
Okay,
property.
now he doesn't want to talk to you.
I've never wanted to talk to you. It's on camera.
Sir, did you ask for a supervisor?
I didn't. I asked for you to get him off my property because he wouldn't leave me alone.
Do you mind if I explain to you what we're here?
I don't want to know. I just want to stop being
Your neighbor said
harassed.
People are breaking into cars.
Oh, that has nothing to do with me. That's y'all's job. I can't help
So
you
he
with
thought
that.
someone was breaking into your car.
No, he didn't.
That's what he said. He literally he radioed out with somebody. Hey, I think this guy might be in the
I'm laying in my hammock on my phone, dude.
Dude, I totally get it. We're here because the neighbor said there's people breaking into
Okay,
the cars.
no.
We're just trying to keep the
No,
neighborhood safe.
we're good.
Okay. Have a better night.
Thank you.
What's up? We back, you know what it is. So we getting involved now into the traffic, or we're diving into, should I say. So let's get into it straight off the jump. I'll start explaining. This time I'll try to not get as loud as I was in the last episode. So traffic, having defined the terms automobile, motor vehicle, traveler, driver, and operator, the next term to define is traffic. And again, we've already gone over those terms in the first part. So it says, quote, traffic thereon is to some extent destructive, therefore, the prevention of unnecessary duplication of auto transportation service will lengthen the life of the highways or reduce the cost of maintenance. The revenue derived by the state will also tend toward public welfare by producing at the expense of those operating for private gain some part of the cost of repairing the wear. Unquote. Northern Pacific Railroad Company versus Shortfelt.
100.
Note, in the above, Justice Tolman expounded upon the key of raising revenue by taxing the privilege to use the public roads at the expense of those operating for gain. In this case, the word traffic is used in conjunction with the unnecessary auto transportation service, or, in other words, a vehicle for hire. The word traffic is another word, which is to be strictly construed to the conducting of business. Quote, traffic, commerce, trade, sale, or exchange of merchandise, bills, money, or the like. The passing of goods and commodities from one person to another for an equivalent in goods or money. Unquote. Bouvier's Law Dictionary, 1914. Here again, notice that this definition refers to one conducting business. No mention is made of one who is traveling in his automobile. The definition is of one who is engaged in the passing of a commodity or goods in exchange for money, i.e., vehicles for hire. Furthermore, the word traffic and travel must have different meanings, which the courts recognize. The difference is recognized in ex parte dicti supra. Quote, in addition to this, cabs, hackney coaches, omnibuses, taxicabs, and hacks, when unnecessarily numerous, interfere with an ordinary traffic and travel and obstruct them. Unquote. With the ordinary traffic and travel. You understand that? They implied these rules, regulations, because they were flooding in the roads. Why do you think we got all this traffic? Because of all the commercial business. So if y'all gonna come through and start flooding up our public roads, we must there tax you for it, because you are using the roads in a commercial capacity. The court, by using both terms, signified its recognition of a distinction between the two. But what was the distinction? We have already defined both terms. Now to nail the matter down. Quote, the word traffic is manifestly used here in secondary sense and has reference to the business of transportation rather than to its primary meaning of interchange of commodities. Unquote. Allen versus City of Bellingham, 1917. Here, the Supreme Court of the State of Washington has defined the word traffic in either its primary or secondary sense in reference to business and not to mere travel. So it is clear that the term traffic is business related and therefore it is a privilege. The net result being that traffic is brought under the police power of legislature. Now remember, and as I'll show you here, police power. And right underneath it shows within constitutional limitations. The term has no application to one who is not using the roads as a source of income or a place of business. License. It seems only proper to define the word license, as the definition of this word will be extremely important in understanding the statutes as they are properly applied. Quote, the permission by competent authority to do an act which without permission would be illegal, a trespass, or a tort. People versus Henderson. Quote, leave to do a thing which licensor could prevent. Western Electric Company versus Passant Reproducer. In order for these two definitions to apply to this case, the state would have to prove the position that the exercise of a constitutional right to use the public roads in the ordinary course of life and business is illegal, a trespass, or a tort, which the state could then regulate or prevent. This position, however, would raise constitutional questions, as this position would be diametrically opposed to the fundamental constitutional law. See conversions of a right to a crime. In the instant case, the proper definition of license is, quote, a permit granted by an appropriate governmental body, generally for consideration to a person, firm, or corporation, to pursue some occupation or to carry on some business which is subject to regulation under police power. Rosenblatt versus California State Board of Pharmacy. This definition would fall more in line with the privilege of carrying on business on the streets. Most people tend to think that licensing is imposed by the state for the purpose of raising revenue, yet there may well be more subtle reasons contemplated. For when one seeks permission from someone to do something, he invokes the jurisdiction of the licensor, which in this case is the state. In essence, the licensee may well be seeking to be regulated by the licensor. Quote, a license fee is a charge made primarily for regulation. with the fee to cover costs and expenses of supervision or regulation," unquote. State versus Jackson. So now do you see what's going on? Do you understand? When you go out and get the driver's license, you are then saying, "I want to be regulated, and I am covering the costs and expenses of you to regulate me." Open your eyes. Realize who you are. You are a living being. You are free. There is nothing to fear from being free. Only that you may have those who are ignorant and cannot understand your freedom in the same way in which you see it. Just because one has been indoctrinated to believe in a certain way as though they are subject to an authoritative figure in any regard does not mean you have to as well. Our forefathers died for your freedom. Why are you disrespecting them by not recognizing it? Do not let those deaths be in vain, for there is blood that has been shed for you to be free. The fee is the price, the regulation or control of the licensee, which is the real aim of the legislation. Are these licenses really used to fund legitimate government, or are they nothing more than a subtle introduction of police power in every facet of our lives? Have our enforcement agencies been diverted from crime prevention, perhaps through no fault of their own, now busying themselves as they check our papers to see that all are properly endorsed by the state?
100.
At which legislative session will it be before we are forced to get a license for lawnmowers, generators, tillers, and air conditions, or before women are required to have a license to use a blender or mixer? All have motors on them, and the state can always use the revenue. At what point does the steady encroachment into our liberty cease?
Can't touch this.
Now we'll move on to police power. The confusion of the police power with the power of taxation usually arises in cases where the police power has affixed a penalty to a certain act or omission to act, or where it requires licenses to be obtained and a certain sum be paid for certain occupations. The power used in the instant case cannot, however, be the power of taxation, since an attempt to levy tax upon a right would be an open to constitutional objection. See taxing power. Infra. Each law relating to the legitimate use of police power must ask 3 questions. 1. Is there threatened danger? 2. Does a regulation involve a constitutional right? 3. Is the regulation reasonable? People versus Smith. Bouvier's Law Dictionary 1914 under police power. Number 1. First. Is there a threatened danger in the individual using his automobile on the public highways in the ordinary course of life and business? The answer is no. There is nothing inherently dangerous in the use of an automobile when it is carefully managed. Their guidance, speed, and noise are subject to a quick and easy control under a competent and considerate manager. It is as harmless on the road as a horse and buggy, possibly more so. It is the manner of managing the automobile, and that alone, which threatens the safety of the public. The ability to stop quickly and to respond quickly to guidance would seem to make the automobile one of the least dangerous conveyances. See Yale Law Journal, December 1905. Quote, "The automobile is not inherently dangerous." Cohen versus Meadow. Blair versus Broadwater, 1917. To deprive all persons of the right to use the road in the ordinary course of life and business, because one might in the future become dangerous, would be a deprivation not of the right to travel, but also the right to due process. 2. Next, does the regulation involve a constitutional right? The question has already been addressed and answered in this brief, and need not be reinforced other than to remind this court that this citizen does have the right to travel upon the public highway by automobile in the ordinary course of life and business. It can therefore be concluded that this regulation does not involve a constitutional right. The third question is the most important in this case. Is this regulation reasonable? The answer is no. It will be shown later in regulation infra that this licensing statute is oppressive and could be effectively administered by less oppressive means. Although the 14th Amendment does not interfere with the proper exercise of the police power in accordance with the general principle that the power must be exercised so as to not invade unreasonably the rights guaranteed by the United States Constitution, it is established beyond question that every state power, including the police power, is limited by the 14th Amendment and others, and by the inhibitions there imposed. Moreover, the ultimate test of the propriety of police power regulation must be found in the 9th Amendment, since it operates as a bulwark to limit the field of police power to the extent of preventing the enforcement of statutes and denial of rights that the Constitution protects. See Parks v. State, 1902. Quote, with regard particularly to the U.S. Constitution and it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Unquote. Conley v. Union Sewer Pipe Company, 1902, and Lafarriere v. Grand Trunk Company in 1892, as well as O'Neill v. Providence Amusement Company. Quote, the police power of the state must be exercised in subordination to the provisions of the U.S. Constitution, unquote. Panhandle Eastern Pipeline Company versus Highway Commission, 1935, and Buchanan versus Worley in 1917. Now, what people are not understanding when they come and they start referring to the police power, the state has police power, but yes, it's still in subordination to the provisions of the U.S. Constitution. Understand that the limitations are still set. Quote, it is well settled that the constitutional rights protected from the invasion by the police power includes rights safeguarded by both the express and implied prohibitions in the constitutions, unquote. DeKay versus Osborne, 1925. Quote, as a rule, fundamental limitations of regulations under the police power are found in the spirit of the constitutions, not the letter, although they are just as efficient as if expressed in the clearest language, unquote. Mehlos versus City of Milwaukee, 1914. As it implies in the instant case, the language of the Fifth Amendment is clear. No person shall be deprived of life, liberty, or property without due process of law. As has been demonstrated, the courts at all levels have firmly established an absolute right to travel. In the instant case, the state, by applying commercial statutes to all entities, natural and artificial persons alike, the legislature has deprived this free and natural person of the right of liberty, without cause and without due process of law. Now we move into the section of due process. The essential elements of due process, quote, the essential elements of due process of the law are notice and the opportunity to defend, unquote. Simon versus Kraft, 1901. Yet, not one individual has ever been given notice of the loss of his or her right before signing the license or contract. Nor was the citizen given any opportunity to defend against the loss of his or her right to travel by automobile on the highways in the ordinary course of life and business. This amounts to an arbitrary deprivation on liberty. Quote, there should be no arbitrary deprivation of life or liberty, unquote. Barbier versus Kanoff, the law Ollie, in 1885, and Yikwu versus Hopkins in 1886. And, quote, the right to travel is part of the liberty of which a citizen cannot be deprived without due process of law under the Fifth Amendment. This right was emerging as early as the Magna Carta, unquote. Kent versus Dulles, 1958. So right there is a clear distinction. If we started even going into the Magna Carta, I mean, we're talking about before our Constitution was even developed. So this has been understood quite freely. and for a long time. So for now to see that some corporations are trying to manipulate your mind frame, like say for instance today, as the recording of this video on, what is today's date? Today's date is the 29th of December 2022. Audit the Audit released a video with a clear misinformed and clear misleading and misinformation to make his viewers feel as though they must fall under an authoritative state of being. The misinformation there is clear, and there has been a clear choice that has been made. It makes you wonder who is actually funding this YouTube channel. The point of this question of police power and due process must balance upon the point of making the public highways a safe place for the public to travel. If a man travels in a manner that creates actual damage, an action in law would be appropriate remedy, civilly, for recovery of damages. The state could then also proceed against the individual to deprive him of his right to use the public highways for cause. This process would fulfill the due process requirements of the Fifth Amendment, while at the same time ensuring that rights guaranteed by the Constitution for the United States of America and the respective state constitutions would be protected for all. But unless or until harm or damage, a crime, is committed, there is no cause of interference in the private affairs or actions of a sovereign citizen.
Can you dig it? Can you dig it? Can you dig it?
But unless or until harm or damage, a crime, is committed, there is no cause or interference in the private affairs or actions of a living being. One of the most famous and perhaps the most quoted definitions of the due process of law is that of Daniel Webster in his Dartmouth College case for Wheat in 1819, in which he declared that due process means, quote, a law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial, unquote. See also State v. Strasburg in 1910 and Dennis v. Moses. Somewhat similar is the statement that is a rule as old as the law that, quote, no one shall be personally bound, restricted until he has had his day in court, unquote, until he has been duly summoned to appear and has been afforded an opportunity to be heard. Judgment without such summons and opportunity lacks all the attributes of a judicial determination. It is judicial usurpation, and it is oppressive, and can never be upheld where it is unfairly administered. Note, this sounds like the process used to deprive one of the privilege of operating a motor vehicle for hire. It should be kept in mind, however, that we are discussing the arbitrary deprivation of the right to use the road that all living beings have in common. The futility of the state's position can most easily be observed in the 1959 Washington Attorney General's opinion on a similar case. Quote, the distinction between the right of the citizen to use the public highways for private rather than commercial purposes is recognized, and, quote, under its power to regulate private uses of our highways, our legislature has required that motor vehicle operators be licensed. Undoubtedly, the primary purpose of this requirement is to ensure, as far as possible, that all motor vehicle operators will be competent and qualified, thereby reducing the potential hazard of risk of harm to which other users of the highways might be otherwise be subject. But once having complied with this regulatory provision by obtaining the required license, a motorist enjoys the privilege of traveling freely upon the highways. Washington AGO 59-69, number 88, page 11. This alarming opinion appears to be saying that every person using an automobile as a matter of right must give up the right and convert the right into a privilege. This is accomplished under the guise of regulation. This statement is indicative of the insensitivity, even the pretended ignorance of the government to the restriction placed upon government by and through the several constitutions. That legal proposition may have been able to stand in 1959. However, as of 1966, in the United States Supreme Court decision in Miranda clearly demonstrated that even this weak defense of the state's actions must fail. Quote, where rights secured by the Constitution are involved, there can be no rulemaking or legislature which would abrogate them. Unquote. Miranda versus State of Arizona in 1966. Thus, the legislature does not have the power to abrogate the citizen's right to travel upon the public roads by passing legislation forcing the citizen to waive his right and convert that right into a privilege. Furthermore, we have previously established that this privilege has been defined as applying only to those who are conducting business in the streets or operating for-hire vehicles. The legislature has attempted by legislative fiat to deprive the citizen of his right to use the roads in the ordinary course of life and business without affording the citizen the safeguard of due process of law. This has been accomplished under supposed powers of regulation. Regulation. In addition to the requirement that regulations governing the use of the highways must not be violative of constitutional guarantees, the prime essentials of such regulation are reasonableness, impartiality, and definitiveness or certainty. Unquote. 25 Amsgers v. Highways, Section 260. And, quote, moreover, a distinction must be observed between the regulation of any activity which may be engaged in as a matter of right and one carried on by government sufferance of permission. Unquote. Davis versus Massachusetts, and Packard versus Banton. One can say for certain that these regulations are impartial since they are being applied to all, even though they are clearly beyond the limits of the legislative power. However, we must consider whether such regulations are reasonable and non-violative of constitutional guarantees. First, let us consider the reasonableness of this statute requiring all persons to be licensed, presuming that we are applying this statute to all persons using the public roads. In determining the reasonableness of the statute, we need only to ask two questions. Does the statute accomplish its stated goal? The answer is no. The attempted explanation for this regulation, quote, to ensure the safety of the public by ensuring, as such as possible, that all are competent and qualified. Unquote. However, one can keep his license without resetting. From time to time, he or she is the first licensed until the day he or she dies, without regard to the competency of the person, by merely renewing said license before it expires. It is therefore possible to completely skirt the goal of this attempted regulation, thus proving that this regulation does not accomplish its goal. If an analysis were compiled of all accidents between those individuals having a license and those who do not, it would reveal that the biggest percentage of accidents were had by those who had licenses. A license does not, in and of itself, guarantee the safety of the general public, much like this license to practice law or medicine assure that only competent lawyers and doctors apply for the trade. A review of the annual malpractice lawsuits is the only proof necessary to establish that it does not. Furthermore, by testing and licensing, the state gives the appearance of underwriting the competence of the licensees, and could therefore be held liable for failures, accidents, etc. caused by licensees, as the state has certified through the issuance of the license that the individual is competent. Is the statute reasonable? The answer is no. This statute cannot be determined to be reasonable since it requires the citizen to give up his or her natural right to travel unrestricted in order to accept the privilege. The purported goal of this statute could be met by such less suppressive regulations, i.e., competency tests and certificates of competency before using an automobile upon the public roads. This is exactly the situation in the aviation sector. But isn't this what we have now? The answer is no. The real purpose of this license is much more insidious. When one signs the license, he or she gives up his or her constitutional right to travel in order to accept and exercise a privilege under contract. After signing the license, a quasi-contract, the citizen has given the state his or her consent to be prosecuted for constructive crimes and quasi-criminal actions where there is no harm done and no damaged property.
100.
These prosecutions take place without affording the citizen their constitutional rights and guarantees, such as the right to travel by jury of 12 persons, and the right to counsel, as well as the normal safeguards such as the proof of intent and corpus delicti, and a grand jury indictment. These unconstitutional prosecutions take place because the citizen is exercising a privilege and has given his or her implied consent to legislative enactments designed to control interstate commerce, a regulated enterprise under the police power of the state. We must now conclude that the citizen is forced to give up constitutional guarantees of right in order to exercise his state privilege to travel upon the public highways in the ordinary course of life and business. Moving on to the section of surrender of rights. A citizen cannot be forced to give up his or her rights in the name of regulation. Quote, the only limitation found restricting the right of the state to condition to the use of the public highways as a means of vehicular transportation for compensation are, number one, that the state must not exact of those it permits to use the highways for hauling for gain, and that they surrender any of their inherent U.S. constitutional rights as a condition precedent to obtaining permission for such use. Riley v. Lawson. Stevenson v. Benford. If one cannot be placed in a position of being forced to surrender rights in order to exercise a privilege, how much more must this maxim of law then apply when one is simply exercising, putting into use, a right? Quote, to be that statute which would deprive a citizen of the rights of person or property without a regular trial, according to the course and usage of the common law, would not be the law of the land. Hoke v. Henderson. And we find it intolerable that one constitutional right should have to be surrendered in order to assert another.
Can you dig it? Can you dig it? Can you dig it?
Quote, we find it intolerable that one constitutional right should have to be surrendered in order to assert another. Simmons v. the United States. Since the state requires that one give up rights in order to exercise the privilege of driving, the regulation cannot stand under the police power, due process, or regulation, but must be exposed as a statute which is oppressive and one which has been misapplied to deprive the citizen of rights guaranteed by the United States Constitution and the state constitution. Taxing power. Quote, any claim that this statute is a taxing statute would be immediately open to severe constitutional objections. If it could be said that the state had the power to tax a right, this would enable the state to destroy rights guaranteed by the Constitution through the use of the oppressive taxation.
Yes, sir.
The question herein is one of the state taxing the right to travel by the ordinary modes of the day, and whether this is a legislative objective of the state taxation. The views advanced herein are neither novel nor supported by authority. The Supreme Court had repeatedly considered the question of taxing power of the states. The right of the state to impede or embarrass the constitutional operation of the United States government, or the rights of the citizen holds under it, has been uniformly denied.
Yes, sir.
Unquote. McCullough v. Maryland in 1819.
100.
The power to tax is a power to destroy. And if the state is given the power to destroy rights through taxation, the framers of the Constitution wrote that document in vain.
100.
Quote, it may be said that a tax of $1 for passing through the state cannot sensibly affect any function of government or deprive a citizen of any valuable right. But if a state can tax a passenger of $1, it can tax him $1,000, unquote. Crandall v. Nevada in 1867. And, quote, If the right of passing through a state by a citizen of the United States is one guaranteed by the Constitution, it must be sacred from state taxation. Therefore, the right to travel must be kept sacred from all forms of state taxation. And if this argument is used by the state as a defense of the enforcement of this statute, then this argument also must fail. Section now that we're going to dive into is conversion of a right to a crime. Now, all this that we've been going over is so true, and you know it rings true to your heart. When did you ever really think, like, what you think you were just born into a world? Yo, you are a creation of the Creator with all the consciousness that you have within you, and you know it. You are the greatest creation of the Most High. Look at you.
Yes, sir.
Understand everything that you are. What makes another man in another title because he went to school have more authority than you?
Yes, sir.
What makes a man that went 6 months to 9 months to school have the authority to kill another?
Yes, sir.
Don't you see? Can this veil not be broken? You know, tonight I took a moment to look at some of the people who don't like sovereign citizens, apparently. I just typed in sovereign citizen fail. And I'm watching people watch other people be in pain. And they laughing about it, yo. They literally laughing about it. These people ain't hurt nobody. They minding their own business. Granted, they could be doing drugs, but they minding their own business. I can understand drugs and violence, but if that's not being done, you're not catching someone in the act of doing that, why are they punished? Because it goes against... I just don't understand why we are not free in the country that is ours. Like, it's gotten too far to where we have to backstep. We have to... there was a great analogy I heard tonight by Brian, and it was, you gotta fight for your liberty. It's kind of like being in a canoe and you paddling upstream. As soon as you let go of the oar or quit paddling, you going back. You gotta fight for your freedom. Like, you have to. If you got children, you have to. The encroachment has gone too far, y'all. I'm gonna quit. I'm gonna stop. As previously demonstrated, the citizen has the right to travel and to transport his property upon the public highways in the ordinary course of life and business. However, if one exercises this right to travel without first giving up the right and converting that right into a privilege, the citizen is by statute guilty of a crime. This amounts to converting the exercise of a constitutional right into a crime.
Can you dig it? Can you dig it? Can you dig it?
Recall the Miller versus the United States and Scheer versus Cullen from page 5. The state cannot diminish rights of the people.
100.
Hurtado versus California in 1883. And, quote, where rights secured by the Constitution are involved, there can be no rulemaking or legislature which would abrogate them, unquote, Miranda. Indeed, the very purpose for creating the state under the limitation of the Constitution was to protect the rights of the people from intrusion, particularly by the forces of the government itself. So we can see that any attempt by the legislature to make the act of using the public highways as a matter of right into a crime is void upon its face, y'all. Any person who claims his right to travel upon the highways and so exercise that right cannot be tried for a crime of doing so. It's clear. This is easy. So, like, all these people that make fun of you, this is a deeper understanding. Like, this is what lawyers use to go into court and fight cases, because they speak on deeper principalities, on deeper understandings and interpretations of the law. People can present their own opinions and interpretations of the law. That's how it works. You put forth your understanding of it and stand on your ground, and you good to go, because you know that you are acting upon everything that the Most High has given you. The great creator of all, y'all. Whatever religion you fit in that, there has to be some kind of understanding that this just, like, come on, man. You have to stand on that, knowing that you are that creation. Any person who... Okay, and yet this sui juris stands before this court today to answer charges for the crime of exercising his right to a liberty. Y'all remember, this is a motion that we are filing, so I'm actually taking y'all through the longer portion of the motion. There's two parts to this motion. And we'll go over the first part, I guess, after the second portion, the support of the memorandum. But it's all good. As we have already shown, though, the term drive can only apply to those who are employed in the business of transportation for hire, okay? And it has been shown that freedom includes the citizen's rights to use the public highways in the ordinary course of life and business, without license or regulation by police powers of the state. Title of nobility. The Constitution for the United States of America at Article 1, Section 10, Clause 1 prohibits the granting of a title of nobility. It states, quote, "No state shall grant title of nobility," unquote. Since the granting of a title of nobility is absolutely prohibited, this court lacks subject matter jurisdiction to enforce a title of nobility and its attendant rules and regulations. Do you understand this?
Yeah, boy.
You can't grant me no title of nobility. You can't give me the permission in which you seek to fit into your way of life. I am a free man. If I choose to be a part of your system, you can do that. But you cannot enforce it upon me as though I do not have the free will choice. That is America. Do you not get it? They cannot force anything upon you. So with that being said, you know, this is going to end part 2, but I just want y'all to know that we're coming around again with a part 3. We're going to have more videos. We're going to have, soon I'm going to show proof of the dismissals, and we're just going to keep educating and empowering ourselves more and more, and that's what it's all about. So y'all stay tuned for part 3. This is power inherent in the people. You already know, all power inherent in you.
Can you dig it? Can you dig it? Can you